All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Please be seated. Clause number 04220082CB in the interest of I.M.D, and M.V.D. Any announcements?
Greg Van Cleve, President.
Okay, please sit down. To my right is Justice Selena Chapa, and to my left is Justice Lori Valenzuela and Patricia Alvarez. And I would ask the appellant if he is ready to start.
Yes, I am.
Please proceed.
Thank you, Your Honor. Your Honor, this is my client's appeal of a motion to enter a partial or a mediated settlement agreement into a final settlement agreement and final order of the rendition order of the case. Now, my client went with my associate to the mediation, and the mediation was becoming very protracted. And during the course of the mediation, the mediator determined that it made more sense to only mediate some of the issues and not all of the issues. At that point, the way they do mediations now is, with this COVID land, is you do the mediations and you write up, the sheet that basically is like the term sheet of what you're talking about, and then you sign it, and then that document that's basically the formulation of the agreement gets put on top of a cover letter that basically talks about the technicalities of it. Now, in the technicalities portion, there was a Mother Hubbard clause, and I guess Elizabeth, my associate, didn't pick up on the Mother Hubbard clause and see it as a final rendition of the entirety of the case, because during the mediation, they specifically said that these particular items were not going to be a part of the mediation. The items were basically related to the child custody. It's right of first refusal is important because the appellant's always out of town. And, in effect, my client's children are being raised by the stepmother, which, there should be, at least my client should have the right to discuss about a right of first refusal, which wasn't discussed. There's a situation where my client doesn't have access to cell phones with the kids, and that was never discussed in the mediation. It wasn't a part of the final agreement. And then there was my client wants to put together a co-parenting plan to make sure that the kids are happy and healthy. They want to play their sports, they want to do the things that that they just are comfortable doing, and she wants to take an active role in their lives in that regard. So for several months, Miss Elizabeth, my associate, was going back and forth with him on other things related to the case. And then out of the blue, they filed a motion to enter a final order on this mediated settlement agreement. So, of course, we were dumbfounded by that because, the whole idea of this particular mediation was it was going to be a partial resolution of the issue. So for my understanding from Miss Elizabeth was that for the better part of 2 months, they were going back and forth about things that were not related to the settlement agreement, still going over the case. And then all of a sudden they got this motion to enter. I have 3 principal issues with this, as I outlined in my brief. The first issue is that we don't think that a Mother Hubbard clause is in and of itself demonstrative of the fact that the case is finalized.
Why not?
Because there's case law that says that from the Supreme Court. I outlined in brief that in my argument.
But is this a case of finality of a mediated settlement agreement, or is it a case of whether this mediated settlement agreement conforms to the final judgment, to the court's order? Because I see that the court's order or judgment covers everything in the mediated settlement agreement.
Yes.
Plus, indirectly covers the cell phone issues, the communication issues, and the three issues that you say were not included.
Yes.
So tell me.
Yeah, so we believe that the mediated settlement agreement wasn't a full rendition of the agreement of the parties because it was only supposed to be a partial settlement of the case.
But it doesn't say anywhere here. And in fact, it says this agreement is not subject to revocation, and you're asking us to set it aside.
Well, no, I'm not asking you to set the,
You're asking us to include the three issues, right?
no, I'm asking you to, to me, the word revocation
Yeah.
means to revoke or to rescind,
Uh-huh.
right? And we're not asking to rescind whatever happened at the mediation. What happened at the mediation happened, right? What we're asking to do is to
Add.
yes, is add. So it's not rescind. So when it says in bold, this is not meant to be rescinded.
Right.
We're agreeing. We're saying that that's fine.
Okay.
It isn't supposed to be rescinded. What we're wanting to do is have it finalized like it was supposed to be. So that's where we are, is that we're saying that we don't want it rescinded. We're comfortable with the idea that that the mediated settlement agreement was mediated to the extent that it was mediated.
But it's not complete.
Exactly. Yeah. So yeah, that's exactly what we're getting at. It's not a complete rendition of the agreement of the parties because the parties specifically decided to not mediate specific items.
But at the mediation, the parties were there, correct?
I via Zoom.
Okay, and were they there to, did they sign the documents? Was counsel there? Was counsel signing these documents? So in other words, did all four parties to counsel and the two parties, were they all present? And
Yes.
did they sign this agreement?
Yes, they did.
Okay.
Exactly.
So what you're telling us is that it doesn't meet 153.0071, right?
Yes.
Okay, and why is that? Because I see 153.0071 and I see the mediated settlement agreement, and I can't understand where you're coming from in that sense.
Well,
Explain it to me.
well, I guess what I'm trying to get at is that we're not trying to, like I said, rescind the settlement agreement. What we're trying to
Okay.
do is
That's clear.
yes, exactly. So the idea of the family code statute is that, you know, a nasty divorce is supposed to be put to bed at the settlement, and that's supposed to be what it is, right? But in this situation, the parties didn't come to a full agreement. So before I discussed what they did is the parties have basically the term sheet of their agreement, and that term sheet gets signed. And then over that, they overlay the legalese document, if you may, that basically identifies it identifies everything. So it was the legalese component of it that had the Mother Hubbard clause.
Okay,
Okay.
proceed with that issue.
So, yeah, so it was the legalese component that I guess has the language that's problematic to my client. And that was not, that wasn't focused on with my client when she was reading the term sheet, which was what
But she was
felt.
represented there, right?
Yes.
Okay.
She was represented. So it's been our experience that Mother Hubbard clauses are not completely demonstrative of the case being finalized.
Uh-huh.
And that's been,
Mr. Van Cleve, are you suggesting the Mother Hubbard clause was not incorporated in the signed mediated settlement agreement?
no,
Or am I not following what you're saying?
no, what I'm saying is that the Mother Hubbard clause is not automatically now determinative that it finalizes the case.
Okay, when did you first become aware that the mediated settlement agreement was not a final rendition of the parties' agreement? And you're suggesting that it was a partial settlement agreement. When was that first recognized? And when was the trial court made aware of that?
Okay, so the mediated settlement agreement happened, and I believe several months later, they filed a motion to enter. At that point, we explained to Ms. Russell explained to the trial court that this was not a full settlement of the agreement. And she corroborated that with the fact that several negotiations related to unrelated things to the case had gone on during the time period between the date of the mediation and the date of the filing of the mediated settlement agreement.
Okay, the three issues that you would like for this court to consider in terms of them not being negotiated for the mediated settlement agreement, did any of those issues arise between the time that the mediated settlement agreement was signed and the time of the hearing?
No, those were always issues. And they specifically addressed,
So why were during those several months, you said there were several months time period. Why was it not brought to the court's attention sooner than several months?
well, we never realized, Ms. Russell never realized that it was an issue until the motion to enter was filed.
Okay, but is it, with all due respect, Mr. Van Cleve, she was represented by counsel,
Yes, she was.
correct?
Yes,
Okay. You can continue. Thank you.
thank you. So another issue is that the in the mediated settlement agreement it specifically says that if there are disputes and issues related to the it's review point number 2, related to the interpretation and performance of the agreement, that would need to be worked with between in a phone conference or otherwise with the mediator who facilitated the settlement. That was never done. We attempted to work it out with him as soon as we realized that was an issue, and he was pretty non-responsive in his communications. So that component of the mediated settlement agreement was not.
That's in a mandatory clause. It's just, try to resolve it.
Yes, no, I get
Yeah,
that. I
it's
get
not
that.
mandatory, right?
Yeah. Well, I mean, it does
You
say
could have
that.
made, your client and her attorney could have made it mandatory. You shall, the party shall.
Well, it says that they agreed that they're going to reach out to the mediator if there's a dispute, and they didn't.
Reach out is not shall reach out.
Okay, I agree. It doesn't say shall or must. Yeah. But it also doesn't have permissive language like may in it either.
No, it doesn't. You're right.
So it basically says that they agree to do that and they didn't. So I think agree is more of a shall than a permissive. So the last thing is that, our concern is that this would act as a res judicata bar related to my client's rights to litigate these issues for several years. And obviously if the kids are, so it could be for several of the kids times as they're, as their minority.
Now, let's talk about the temporary orders. The temporary orders do have the 3 issues that Justice Chapa was alluding to. The right of first refusal, the electronic communications with the children, and the cell phone communications with the children, right?
Yeah.
So isn't aren't the temporary orders incorporated to the mediated settlement agreement?
No,
You don't think so?
I don't think so.
Okay.
It would make sense if they would be, but they weren't.
But aren't they by law incorporated, or are they just set aside, the temporary orders?
I mean, I know that, there's an axiom that kind of says temporary becomes permanent in our profession, but I think that's more of an axiom. I don't think that's a reality. Yeah.
It's not written
Yeah.
in
Yeah.
here,
Yeah,
right?
that's my understanding.
Okay, okay.
Yeah, so that was
I
kind of where that
understand.
is.
And I apologize for taking you in.
No,
These
that's,
are questions we have and we've been.
no,
dealing
I
with
appreciate
this.
that.
Uh-huh.
Yeah. Do you have any other questions for me?
Yeah, what about the issue of you, I believe it was you who asked us to have a finding of claim preclusion. Tell us,
That there would not be a claim.
oh,
preclusion.
there would not be,
Yeah.
I stand corrected, there would not be. Tell us about that.
Well, I mean, my client would like the right to relitigate, if possible, these issues. If,
The 3 issues
The
or
3
all of the
issues.
issues?
no, the 3 issues,
Uh-huh.
because she would like to get this. She'd like to have the ability to talk to her kids outside of her time window.
Presence.
Yes.
Uh-huh.
And the father takes the phone away and doesn't, when he's mad at them, and when he takes the phone away from, the ability to talk to their friends, he also precludes him from talking to the mom,
Uh-huh.
which is a problem to the mom because she likes to have an active role in her kids' lives. Right. I mean, so that's kind of where that is. And, as far as extracurricular, the kids want to play sports. The father doesn't want to let them. She would like to let them play soccer. She'd like to let them play baseball. These are things that she would like to be able to do with them. That she's been done, that the father doesn't want to do and can't do because he travels.
Now, are you asking us to send this case back to the trial court so those 3 items can be incorporated into a new mediation settlement agreement or mediated settlement agreement?
Well, I would like us to either we could go back to another mediation and mediate out those particular issues, or we could just reverse it and have it understood that what was mediated was actually mediated and what wasn't mediated isn't. So then that would be a very finite thing for a trial court to resolve.
Okay, so I guess, and I'm trying to figure out how we would do that if we do go your way. You're asking us to send it back, maybe with with instructions to the court just to address these 3 issues and incorporate them to her judgment, or how do you want us to work that?
Well, what I would think you would do is you would have an order that said that the mediated settlement agreement resolved all issues, excluding the 3 issues. And then when we go to trial, we'd just be going to trial on those specific items.
Okay.
Which would only be like a half-day trial. It would be very efficient, So I think that would be a great thing for everybody.
Okay, well, thank you
Okay.
for that.
Okay.
Any
reserve
other
the balance.
questions, justices?
I do have a question. Is there any other legal avenue you can take to try to get your client the relief she's seeking?
I don't believe so. I think that's why I'm so concerned about the res judicata effect of it, because that would preclude in some, my clients having her ability to deal with some of her kids for the balance of their minority, which is an issue for some of them.
But that would be an advisory opinion in our part. Don't you agree?
Absolutely not.
Why not?
Because all you would be doing is declaring or ordering that the mediated settlement agreement mediated specific items. All items except. So that wouldn't be an advisory opinion. An advisory opinion is something along the lines of, if this happens, we recommend you do that. But what y'all are
We don't
doing,
even have to address that if we go your way in the type of order that you want us to issue, then we don't have an issue with issue and preclusion or res judicata, do we?
absolutely not. No.
Okay.
Okay.
I see where you're going.
Thank you.
Thank you very much. We'll
thank
have
you.
10 minutes on rebuttal. Ms. Grossman? And I forgot to tell you, there's water. You can take water to the podium if you'd like. You may proceed.
Thank you. First and foremost, I fully believe that this is an agreement for a final order. While opposing counsel is arguing one specific clause, there's several indications within the mediated settlement that this is to resolve all the issues between the parties and to enter a final order. It includes, they will present evidence on the first available date to enter the order, as well as counsel that will be, which counsel will be drafting the final order. The clause that they're referring to as the Mother Hubbard clause is the statement in the MSA stating that all other relief not granted is denied. They use Lehman to support that argument. However, in that case, the relief not granted is denied was in terms of a hearing that was prior to a final hearing in the midst of the case, and that the relief not granted in that specific hearing, not in the overall case, was thereby denied. Here, it's not only that clause, which makes it so that this is a final agreement for the parties, but all of the other provisions as well. By their argument, by not including certain provisions or agreements within an MSA is opening the door for other parties to be able to come in at any time to be able to relitigate certain issues that were purposely excluded from an MSA, or even so much as to purposely not make discussions or have discussions for certain agreements or provisions in mediation, so that you can then thereby bring it up at a later time and date before a final hearing. Additionally, the motion to enter was not filed until several months after trial counsel had sent the proposed order. In our appendix 10 to our brief, we include the email correspondence, which shows that on December 13th, at the latest, the proposed final order was sent to opposing counsel. At which point there was no indication of any disagreement for the provisions in the order, the incorporation of the provisions of the MSA into the order, nor was it in any way communicated that that wasn't their intention or belief that it was a final order until after they had filed a motion for a child custody evaluation. At which point then it was necessary to file a motion to enter the order as the case was concluded. And it was known that the case was concluded, having resolved all the issues.
But isn't what we're trying to figure out is what does the mediated settlement agreement says versus, you know, whatever it says versus did they wait too long or did they? That's where we need to concentrate on as a court. Don't you agree?
Yes, I do fully agree with that. And in the mediated settlement agreement, there is nothing to indicate that this is just a partial settlement agreement, that there were any provisions left remaining to negotiate or to discuss. If that were the case, then it would have been included in the mediated settlement agreement, that there were provisions or there were certain items that were left for future negotiation or discussion or left to the trial court, but that wasn't included in the mediated settlement agreement. And as far as looking at the agreement, there's nothing to indicate that, nor was it the belief of my client or the child counsel that this was anything but a full resolution of the parties' issues. That if it was left for future negotiations or if they made any agreement for certain issues, that would have been included within the MSA, which it was not.
Well, what happens if material and substantial changes in circumstances arise for any party? What happens then? What legal recourse does a party have?
After a year, either of signing the MSA in this instance or of the final order being entered, then the parties do have the opportunity to file for a modification. In this instance, the parties signed the mediated settlement agreement on November 1st, 2021. So they would have an opportunity after that 1 year mark to file for a modification.
So why are we here?
I am not sure, Your Honor. In terms of
So that you can receive your credit for your.
yes, Your Honor. Yes. In terms of also the biggest issue here is that if the court were to decide that that would be an option for parties to relitigate issues that aren't in an MSA, it creates a lot of issues moving forward as well. In terms of not having full incorporations of agreements, I don't believe that there would ever be any possible way to ever have an actual mediated settlement agreement. Then there's always something that can
Pop up.
some kind of provision to be
Isn't that the
included.
case though with children? Something always pops out, whether it's telephone conversations, cell phone conversations, whether it's more time with the parent, the non-custodial parent. Everything pops out, and that's why it's so open in family law. Don't you agree with that?
I do agree with that. And I think that that's also why the substantial change of circumstances, why that's easy to achieve, is because especially for children, they're always changing and growing, and that there are changes that can be made within a short period of time.
Yeah, and so substantial changes within after a year of a mediated settlement agreement, the fact that a parent doesn't allow a child to talk to the other parent via cell phone or email, that doesn't qualify as a substantial change. Do you agree with that?
I think that it depends on the circumstances. If it's significant to where there's no communication whatsoever, or if it's starting to become an issue for possession, where possession is being denied. While it also may not be a substantial change, there can also be an enforcement if it's a provision that's included in the final order as well, to be able to have that communication in that time of possession as well, if it's not being adhered to by one of the parents as well.
Let me show my ignorance with respect to mediated settlement agreement. Don't you have to file for a breach of contract like you would a Rule 11 agreement?
I don't believe that you have to file a breach of contract. I think that there are cases that indicate that you can plead for certain breach of contract claims, but that it's not necessarily a breach of contract that has to be filed when it pertains to a mediated settlement agreement.
So it's nothing like a Rule 11 agreement.
No, since the mediated settlement agreements, if it comports to the requirements of Texas Family Code 6.602, that it includes the boldface language, that it's non-revocable, and it's signed by the parties in council, that it's not considered a breach of contract pertaining to a mediated settlement agreement. That if it's an informal settlement conference, or if it's some kind of other informal settlement, that if it doesn't include the revocable language, or that it's a Rule 11 agreement and can be revoked, that I believe that the case law indicates that that could be a breach of contract claim instead.
Okay, so there's nothing that would preclude your client right now into entering into a second or an amended mediated settlement agreement with regard to communications between appellant and her children, right?
Well, since it does meet the requirements, the MSA or the mediated settlement agreement that was signed, that it was signed by the parties, was signed by the parties' attorneys, and had the boldface language, that my client would be entitled to a judgment according to the terms of the mediated settlement agreement. I'm not sure pertaining to what Mr. Van Cleve said pertaining to their communication. If there's any issues right now, I would hope that they would be able to resolve those issues or be able to discuss that later on and not need court involvement for that sort of issue. But as pertaining to this matter and what's before the court for appeal, my client would be entitled to a judgment of the mediated settlement agreement and the terms that it contains right now.
What about the clause within the MSA that encourages parties to try to work things out via the mediator in the event that there is a dispute about an interpretation about the language within the MSA?
First and foremost, I don't believe that there was any dispute for the language or interpretation of the actual provisions that were contained within the mediated settlement.
Is that under your purview to decide that?
Well, opposing counsel, it was even included on the record, had no objection to the language of the order itself. That there was no disagreement to the language, to the wording, to the provisions that it contained, only to the 3 provisions that were not included within the mediated settlement agreement.
So you're just, I guess, being hyper technical in terms of whatever's not in the MSA is just, we should completely disregard unless it's a year from now and there's been material and substantial changes in circumstances.
Well, the trial counsel did reach out and discuss over the phone the instances. It wasn't documented, so it wasn't included in the brief or within the appendix, any kind of written format for that. What was included was an email to the mediator that the trial court for appellant had sent to include the mediator in the correspondence after they had already filed and set the motion to confer. Or for the motion for the child custody evaluation, at which point it had already been several months that counsel had been attempting to have the order entered with no response or no disagreements to the language of the mediated settlement agreements incorporation into the order, at which point it was already several months in February that the email was sent. If there was any disagreement on their end in terms of the interpretation that this may have not been a mediated settlement agreement for a final order, that they showed no due diligence in making that effort prior to setting a motion to have a child custody evaluation, and then later the motion to sign. Additionally, once they were aware, I guess at that point that there was this agreement, they provided dates that were mostly after. There was only one date and time prior to the setting for the motion to sign or the motion to confer. And if there were any issues, at which point, again, there was no due diligence in making that effort to.
But is that the lens through which we should be reviewing this case? Based on issues that have been brought before us?
Yes, but I also believe that you have to look at the mediated settlement agreement and what it contains. And there wasn't an agreement that there would be an arbitration by the mediator or that the mediator would make the final resolution for that issue, but that the parties would try to resolve it by a phone conference. And I would say that the poor attempt of the opposing counsel of trying to schedule a phone conference after the fact they did try to, but at which point, again, there should have been more due diligence prior to that point of trying to have a conference before trying to continue on with their case and having a child custody evaluation and reopening the doors to the litigation. I think that would also be difficult at that point to then go back to the mediator once we've already had a hearing and a court has already made a decision for a
What
mediator
you're
to
saying
override
is
that.
that one phone call took place prior to the hearing to enter the MSA.
Yes, the trial counsel did reach out and that there
Okay.
were no there was no disagreements based off of the fact that it was a final mediated settlement agreement, that there was no purpose in having a conversation or a phone conference since it was a mediated settlement agreement and it was final.
Okay, well then if the door was closed, then how much more due diligence can the appellant possibly do?
Well, I think that the discussions or the conversation should have taken place prior to which point, or the attempt should have been made prior to trying to have a
Prior to what,
hearing.
prior to signing the MSA?
No, so the mediated
I'm
settlement
not following what you're
agreement,
saying.
mediated settlement agreement was signed on November 11th.
When
As
did that phone call take place?
so that phone call took place after February 2nd, once the motion for the child custody evaluation was filed.
Thank you for that timely.
Yes, the proposed order was emailed first on December 13th. At which point there was no disagreement to the wording or the language of the final order. And it was then on February 2nd that the motion for the child custody evaluation was filed and set for February 9th. After the evaluation was filed, then trial counsel filed to enter the final order. So having the conversation with the mediator after that point, then would have had to override what a trial court judge had already ordered. And I think that would have created several other issues in this case. I think that since it was a final agreement, that then it becomes an issue of whether the mediator will make that decision or whether the trial court will, or then the trial court then modifying the mediated settlement agreement to incorporate those terms, and then having an order in place that is essentially void for those modifications made to it prior to entry.
Why can't we have another mediated settlement agreement? Number one and number two.
I think that if there was the intent to have two, then it would have been left up there would have been a provision included that it was left for future negotiations, or even a provision that the parties would return to mediation to mediate those specific issues, that this was an agreement pertaining to every other issue. But if there were specific issues left either up for the decision for a trial court or for negotiations, either formally or informally, that would have been something that was included. But it's not included in the mediated settlement agreement, and there's no way for then the other party to have that understanding or intent that there were any provisions that were remaining. Again, otherwise you would be able to continue to relitigate and continue to discuss certain provisions or orders that aren't
No
included.
finality, that's what you're saying.
Yes, absolutely no finality, because I believe that there's always something that, especially pertaining to children, that you can think of to include it in order. That, or something even between a mediated settlement agreement and entry that then may need to be included or may have been thought of at that point. Or even the potential to have left negotiations out specifically out of mediation completely so that you can then relitigate them in the future. Otherwise, you would have to put not only every agreement you make in mediation, but every disagreement in the mediated settlement agreement. And while under the Texas Practice and Remedies Code, section 154 is for all communications during mediation are confidential and shouldn't be discussed or brought into the intent or the interpretation other than what is written in the mediated settlement agreement. And so without even being able to bring in those discussions, there would be no way to know then for sure whether or not certain issues were discussed or not in mediation. They would have to be included in a mediated settlement agreement. And have they not been included, then it's assumed that that's a provision that wasn't agreed to during the mediation. But not being able to discuss the parties' intent or negotiation strategies or discussions, there's no way to know exactly what wasn't agreed to. It's only what is included in the mediated settlement agreement and what was included for the parties.
Any questions, Justices?
I do have a last question. You're seeking sanctions. Why?
Yes, Your Honor. I believe that it's the case law as well as the family code and the Texas Civil Practice Remedies Code is very clear of what a valid mediated settlement agreement is, and that there's plenty of case law to indicate that it is non-revocable, that the party is entitled to judgment on that mediated settlement agreement if it is properly executed as this one is in this case. And so I believe that sanctions are warranted in this matter, given that it is comporting to all of the requirements that are necessary. And that, again, there's nothing to indicate that any provisions were left open or otherwise can be interpreted in any other way besides the finality of an agreement.
But for a groundless lawsuit, Marbury versus Madison would have not happened. So why would we give sanctions to a party that feels, like you heard today, that he has a good case?
Because unfortunately, I don't believe that there is any grounds for that. I don't believe that there's been any case law cited to in their brief that would indicate that this is that their argument or their appeal is warranted. I believe that the one case they cite to, the Lehman case, is even an indicator showing that it is a final resolution of this matter and that not providing any other case law or authorities behind their arguments as well is why it would be warranted here.
Well, I would just caution you, counsel, in that every appellant feels that he or she has a valid case and its legal argument. So I would caution the use of sanctions for circumstances that are egregious, not solely based on legal argument.
Okay. Yes.
Thank you
Thank
very
you.
much. Rebuttal, sir.
I believe that the Lehman case does bolster argument. As she said, it was not the final order, it was a predicate order. And the mediated settlement agreement is an effective predicate agreement to the final order. So the Lehman case makes perfect sense and interrobes very well in that, because it basically says that it's interlocutory in nature. You know, we would not have asked for we wouldn't have taken further steps in litigation had we thought the case was fully resolved. The record shows that Elizabeth was very comfortable thinking that there was still stuff pending on the case. That's why she proceeded, and that's why she wrote emails to them. That's why she continued to communicate in that regard. So this is a situation where my client and her prior attorney were working off the belief that the mediated settlement agreement was a partial, not a partial as opposed to a full settlement of the agreement. And I think so basically what we have here is a situation where, in effect, the legalese cover letter that was interlaced on top of the term sheet, right? It was one that would be used on the basis of a final settlement agreement as opposed to a partial settlement agreement. So the fact that the mediator elected to put the wrong form on the paper and that Elizabeth didn't pick it up, that shouldn't resolve my client's claims. That's basically where we are. My client wants to see her kids, and she wants to talk to her kids. She wants to do what parents do. She wants to take them to soccer. She can't do that because of the terms of the settlement agreement, and that was not agreed to by her. That's why we're here.
Is there anything in the MSA precluding your client from taking her kids to play soccer?
Well, the problem is they want to play like for a team, right? And they can't play for a team when they can only show up on her weekends. That's the issue,
Explain that a little bit more.
Well, if, basically from, my understanding of this, and I'm a real estate lawyer more than a family law lawyer, but I'm going
We
through a
understand
divorce.
that.
But, my understanding of things is, the non-custodial parent, well, the parent without the right to designate home.
For this case, how does that work? In
Well,
this case?
Basically, if my client, if there were to be orders that say that my client's responsible to make sure that the kids get home to, from soccer practice to the father's house, then that would be fine. So, because, my client wants to make sure that can happen. But as it is right now, basically the father controls the kids' schedules on the days that aren't my clients. So if the father controls, the father decides if they have soccer practice or not. The father controls if they have whatever.
Now I understand what you're
Yeah.
doing.
So that's kind of where it is.
Mhm.
So, what we want is the right for both parents to have say in the extracurricular activities of the children.
So you want co-parenting.
Yeah, exactly.
Yeah.
Which I think, and my understanding of what happens at the courthouse is that that's all that the judges want to see is
Mhm.
co-parenting. So then that's what we want. We want my client to have an active, happy role in her kid's life, and she can't do that right now.
And
Because
why
of how
doesn't
it
that
is.
fall under being a joint managing conservator? Is it solely based on visitation?
Yeah, I would believe so. Temporally, the kids are the responsibility of the custodial parent that has the right to determine residency during the times it's not, unless there's a right of first refusal or whatever. But so in our situation, even though, the kids are, waiting at home trying to, watch TV when they could be playing soccer, that's where they are. And it's because it's the dad's time and not the mom's time.
So let me ask you, what were the parties doing between the MSA and when the final order was signed? You said months passed.
Yeah, I believe.
So,
Yeah.
so my question for you is, were the parties engaging in behavior that followed the MSA where your client would have been apprised of the lack of communication with the phone, the inability to pick up the kids for sports, et cetera? In other words, were they already acting like that MSA was in place between MSA and final order, those months in between?
I honestly don't know, because that's, my associate was handling the majority of the case at that time. My understanding is that the status quo was being maintained. That's the extent of my knowledge.
The status quo of the temporary order.
The activity that was, my understanding is that things did not change as far as how the parties were reacting toward one another
Okay.
from before the MSJ or MSA to the date of the final order.
I had the same.
Yeah, it was basically, they were acting as if it was prior to the MSJ time.
Okay.
Yeah.
So just to make sure that I understand your answer to Justice Valenzuela's question. Everything was status quo until you filed the motion for modification or for
The parent, the evaluation.
the evaluation.
And that was
correct?
because there was the issue with the child where she wanted to commit suicide.
Your client is here
Yeah, she's right here.
and your client is here too? No, okay. I just wanted to make sure that it wasn't Mr. De Leon. Okay.
Thank you, Your Honor.
Wait, any questions? No. Please take a seat. Congratulations. Is this your first argument?
Actually,
Your second, congratulations. And congratulations to you, sir. Your case has been submitted and we will have an opinion shortly, maybe within the next month. Okay, thank you very much and you may be excused.
All rise.